Good evening, everyone, and welcome to tonight's Live. I'm Helen Houghton, leader of the New Zealand Conservative Party, and tonight I'm joined by three of our justice spokesmen and women, all here to discuss, of course, justice, as well as the introduction of our reformed justice policy. Before we begin, I'm going to ask you a few questions, but as you can see on the screen there, we have Ross Meurant, who is our Senior Policy Advisor. We also have Stephen Taylor, who has been our Law and Justice Spokesman, and Jan Taylor, who is the Associate Law and Justice Spokeswoman. So we have a really strong team here. There's four of us who are passionate about law and justice and advocacy for all the people. So tonight, the questions I'm going to ask you, first we'll start with, have you ever walked away from a legitimate legal dispute because you couldn't afford to fight it? Do you believe justice in New Zealand has become something that only those with deep pockets can realistically pursue? Have you ever lost confidence in our justice system? Now, if you've answered yes to any of those questions, then tonight's discussion is for you. Okay, now in 2023, I sought justice. I approached a lawyer because I believed that there were some defamatory statements that had been made publicly, and I wanted the opportunity to clear my name. When your reputation is attacked, simply walking away is not an option. Your character matters. Your family, your work, and your future can all be affected. As I soon discovered that seeking justice and being able to afford justice are two very different things. But like anyone facing a specialised legal issue, I needed a lawyer with expertise in defamation. I mean, you wouldn't ask a family lawyer to defend a serious criminal charge or a property lawyer to handle a complex defamation litigation. Experience matters. Then came the reality. Before I could even file in court, I was told I would need around $10,000 just to get the initial legal opinion. And because the case also required a specialist barrister, there would be two ongoing legal costs, or two sets of ongoing legal costs. Now that is before filing a statement of claim, before the first case management conference, before preparing the many documents that were required and are still going to be required, and also before tomorrow's judicial settlement conference that I'm involved in. At the time, when I sought out the lawyer's advice, I wasn't working. Some of you may know I was completing a law degree, which is quite fortunate now. I simply couldn't afford to pay those initial legal fees. And you can probably imagine how much I would have already paid those lawyers by now with all of the filing that I've had to do. So I didn't pay at the time. Instead, I had a choice. Do I abandon justice or do I represent myself? Today, I can assure you, I am representing myself in a defamation case against a major international publisher facing experienced counsel with vastly greater financial resources. And they are also seeking $60,000 in security costs before I can even take my case to trial. Now, my story isn't unique. In fact, across New Zealand, ordinary people settle cases that they believe they could have won. They abandon legitimate claims and sometimes never even begin legal proceedings at all. And it's not because they're wrong, but because the justice has become financially out of reach. And that is why tonight matters. So I'm really grateful to have on board a great team who have helped put together a really good policy that I think will be able to help with the access to justice. Tonight, we're not just talking about what's wrong with the justice system. We're talking about how we believe it can be reformed so that access to justice is based on the merits of the case, not on the size of your bank account. So let's begin. Ross Meurant, our Senior Policy Advisor, could you please explain to the audience what our position is on our updated justice policy? And just quickly, I'd like to welcome all those who have tuned in already. There will be time for questions and comments later on. And for those who tune in at another point to rewatch this, just leave your comments. Thank you, Ross.
Thank you, Helen. Good evening, ladies and gentlemen. Just listening to Helen, aside from the prior costs of filing before you file a statement of claim, I mean, that's a cost imposed by the courts. But the reality of justice in New Zealand is that lawyers and barristers hold the key to the courts where justice might be delivered. The problem, however, is it depends on how much the defendant or plaintiffs can afford. And Helen outlined a situation which is quite common. But let's say, for example, as a defendant, where there's a need to show the court that the police got it wrong, and there are many cases where this is happening. For today, example, the Allen Hall case and the Red Fox Tavern case being two standout examples. Or as a plaintiff in a civil case, having to show that claims of malfeasance or impropriety against you are without foundation. So simplified, if you don't have the financial resources to hire an advocate in court, your cause for justice is lost. One of the problems in seeking this justice is the best of these lawyers or barristers may charge $1,000 an hour. I have proof of a case where the fee charged has been $2,000 an hour. Now, if one extrapolates that over time it takes to prepare a case, and maybe the 2 or 3 weeks a trial in court may last, a legal burden of $2 million is not unheard of. But who can afford that cost to prove their innocence? Often these legal paragons force people to mortgage or sell their homes to pay up front, and the impact on families is massive. So the Conservative Party's justice policy is focused on addressing this, road to justice. So first consideration is to introduce an independent body to monitor and control fees. Now, the Law Society may protest. They would say, we are the handbrake on excessive charge-outs. And they might point to the Barry Hart case as an example. But where are other examples? It's a bit like the IPCA being the handbrake on the police or the independent investigator. But since 1966, 36 people have been shot dead, and only one case has been put before an open court for culpability to be decided. So the point I make here is these entities like IPCA, the Law Society, and even Ombudsman, as one reviews the conduct of many of them, and I am compelled to conclude that their objective is to protect the system rather than provide justice. So hence the Conservative Party is focused on the road to justice, all the costs that have been enunciated tonight, and introducing an independent body to monitor what is charged. So that's one aspect of the policy. What else are we looking at? A ceiling to be applied on all legal fees by lawyers and barristers, and yes, the commission to review the charges. Also, we've got here review the merit of introducing a final appeal court akin to the Privy Council. Again, it's metaphorically speaking, a incestuous community, the legal fraternity. So many judges and high-profile barristers went to the same school, are married to somebody's sister, or they know each other so well. Finding an independent reviewer of these cases when there's a possibility that lawyers and barristers are sorting things out behind closed doors, finding an independent authority like the Privy Council once was, is something that the Conservatives want to review. Finally, there's another issue that has come up on our agenda, and that's to address the issue of social media platforms, Google example, failure to comply with New Zealand law, where people have had clean slates after a specified time, and these convictions they had, which are no longer there, continue to be displayed. So it's a succinct policy, sealing to be applied to all legal fees charged by lawyers, an independent body, independent of the Law Society and the Law Commission, to review the charges by barristers and lawyers, review the merit of introducing a final court of appeal akin to Privy Council, and tidy up loose ends where media breach New Zealand law by disregarding clean slates. So that's about it.
Thank you, Ross. That's fantastic. And we're really grateful to have you on board and helping to get those policies where they're really going to hit the hardest with the people that need it the most. So can we just have, actually, you've just got a comment there from Paul. Awesome, guys, keep up the momentum, and we plan to. We've got a lot coming up for the election, Paul. Thanks for tuning in tonight, and thank you to all the others who are watching tonight. You've got time to ask any questions, type away your comments. That's great, thank you. Can we just now have Stephen, would you like to chat about, I know that you were doing, or currently maybe still doing, your Masters in Law, and one of your I think thesis was around access to justice. So you've got some really good research that you have completed around this. Would you like to share some of that to the audience?
Thank you, Helen, and good evening all. The access to justice, you're right, I'm completing a Master's in Legal Studies. I'm about halfway through. My focus is on litigation and dispute resolution, and a primary focus around access to justice for self-represented litigants. So a number of viewers may know that I run a company called Litigation Support Services, and a primary focus of that company is to assist self-represented litigants to navigate the criminal and civil family court, disputes tribunal jurisdictions. Why the focus on self-represented litigants? Well, there are approximately 10,000 cases right now in the civil jurisdiction across New Zealand, and incredibly surprising to find out that 71%, that's 7,100 of those cases, are being fronted by self-represented litigants. It's an astonishing population, and a figure not that well known. Why are 71% of self-represented litigants representing themselves in the district court? They're caught. They're too rich, and our rich is $28,000 a year, to qualify for legal aid, but they're not rich enough to afford counsel, and average counsel cost at the moment sits somewhere between $400 to $600. If you get a junior counsel, it's probably $350 to $400. If you approach most law firms, they'll seek a letter of engagement and a retainer. It's not unusual for $5,000 to $10,000 to be nominated as the retainer before they'll even look at the file. And so a number of the clients that I work with are caught in this enormous trap. It's not a niche. It's often in legal circles, they talk about the justice gap. We're not talking about a justice gap in New Zealand. We're talking about a justice crevasse, a justice canyon. It is enormous. There's also some quite distinct differences between criminal and civil jurisdiction. In the criminal jurisdiction, if you are a self-represented litigant without counsel, you can walk into a court and there'll be armies of duty solicitors, although they're less these days. More and more lawyers are leaving the bar because it's become too hard for them to provide legal aid because of the very, very low rates that they receive. And so but these judicial lists are available in the civil jurisdiction, not common, and family court doesn't exist at all. So a lot of people, in 2025, the government undertook a review of the legal aid survey, and a lot of people were waiting, lawyers were waiting, and firms were waiting in terms of maybe we'll get an increase in the thresholds, maybe we'll get an increase in funding. A year later, the government came back and said, well, we're going to do a review of the review. There was no progress. What they came up with was a thing called the Accessible and Affordable Justice Program, which is another review which involves a focus panel on how they might improve not only legal aid, but a whole bunch of other aspects around the provision of legal services. So that's shorthand for no progress after over a year of a consultation. Very unfortunate. So part of the work that I did is I compared the access to justice of UK, Australia, and New Zealand. I can provide a copy of that thesis for anyone who might like a copy. Just email me at steve.taylor@relationshipmatters.org.nz. Be happy to send you a copy. And essentially what I found out is that we are way behind the 8 ball in terms of access to justice. And let me give you just one wee example from West Australia, where if couples are separating and they're still able to do it amicably, they have an AI augmented program called Amica, A-M-I-C-A. For a low initial fee, you can feed all your information into the system. It reads thousands and thousands and thousands of cases anchored on precedent, and then spits out at the other end a proposed solution. In 2.5 years of being in service, it's saved over $20 million. That's $20 million in legal fees that separating couples would have had to pay. What do we have? Well, we have a phone-in system if you're remote, and delays in terms of jurisdictional process and adjournments and judges getting sick and the whole 9 yards. You want to go to court, you better put 3 years of your life aside, whether it's the district court, the high court, or court of appeal, Supreme Court, if your application gets that high and if they decide to hear it. But 3 years at the outside, that's 3 years of your life before we even talk about money. So you better be pretty motivated to go to court. The other problem you're going to have is that it's one thing to get access to justice, but what if judges get it wrong? And what does that mean in real terms? Well, in New Zealand, there's just over 220,000 cases heard per year, about 200,000 of those in the district court. Let's assume that judges get it wrong only 1% of the time. That's 2,200 people's lives who are affected. That's at 1%. At 10%, it's 22,000. But we don't measure jurisdictional error. There's no measure within New Zealand that we're able to do that. And so often people are caught at the other end. A judge makes a wrong judgment, and you could go to appeal, but now you're up for another 1.5 to 2 years, and more fees, and more filing, and increased litigation risk. We'll take to Ross's point. These judges know each other. These lawyers know each other. I've seen it in the family court. We've had supposed adversary lawyers, and then a few months down the track, they're all down at the court having a lovely time, being very collegial. Why is that important? Because the number one loyalty that a lawyer has is to the court. As an officer of the court, that's their number one loyalty. What's their number two loyalty? To their profession and their collegiality of their profession. What's third? The client. You're third in terms of priority when you go to a lawyer from a standing start. That's third, not first or second, third. And so a lot of these things aren't known by people who go into the court and who are seeking justice. In fact, we've got it completely wrong. It's not the Ministry of Justice. It's the Ministry of Legal Proceedings. That's what it should be. And I would, if I was in Parliament, I'd be advocating for that to be actually changed in terms of the name. There's no justice in court. Let's be really clear. There's a legal proceeding that is a little bit like lotto, and you might win and you might not. But even if you win, you've paid all this money, and then if you put an application for costs, then you might get declined, or it might be 21% uplift, maybe. So it's a zero-sum game. and often the cost isn't the money so much, although the money is very significant. Ross has made some very good points. The cost is to family and to work and to mental, psychological, and physical health, on the basis that you're playing lotto within the criminal and civil jurisdiction. And so the legal aid thresholds need to be attended to, and in terms of going up, I think there needs to be more money around mediation and litigation dispute resolution, and that we move from an adversarial process to an inquisitorial process. And the inquisitorial process is much stronger in Europe. The adversarial process is desperately ineffective. So we need to move to more inquisitorial process. The other benefit that will give is that judges will be forced to do proper investigation into files and proper investigation into submissions. I've had clients who have it on record where the judge has said, didn't read all the submissions, but made a decision anyway. That's outrageous. And that's a short road to a miscarriage of justice, and a question certainly in terms of the competence of the people who hold a warrant. So that's probably as much as I wish to say today.
Well,
hold on a minute. Okay. Thank you, Stephen. I think my mic was muted. Okay. Now, great input. And did you tell people that you could send out a link to your research, or was that not mentioned? I didn't.
Yes, if anyone would like a copy of the thesis I've written in terms of access to justice, if they can just email steve.taylor@relationshipmatters.org.nz. Relationship Matters is one word, steve.taylor@relationshipmatters.org.nz, and I'll send you a copy of the thesis.
Thank you. That's wonderful. Okay, so just before we have our next speaker, I wanted to just mention along the lines of what you were talking about. So the New Zealand Law Society back in 2021 also did a research through Kantar Research, who used to be Colmar Brunton. They researched lawyers around their the fact that lawyers are also concerned about the ability of the legal system to provide everyone with access to justice. And it came out that half of the lawyers that they spoke to rate the legal system as poor or very poor at providing everyone in New Zealand with access to justice. So there you have it. It's not only us saying this. This is actual lawyers that were approached. I think there was something like around 17 lawyers were emailed from the Law Society. Unfortunately, there were only around 3,000 that did respond. But out of those, half of them also said that they had to turn away clients in the last 12 months. And that's also higher for legal aid lawyers, with 3/4 who had to turn away people seeking legal assistance. So that's just a little bit of additional. And I thought that would be quite nice to bring Jan Taylor in around her advocacy and why she's doing what she's doing. It's very similar to something that I'm also picking up as well. Jan, would you like to make a comment? You need to unmute yourself as well.
Here we go. Kia ora, everybody. Good evening. I'm Jan Taylor. I'm a very passionate advocate in terms of accessing justice for people in New Zealand who are struggling. As everybody on the panel tonight has said, the cost is just astronomical and people just can't afford to access justice. I have a little advocacy group called DAG, Dispute Advocacy Group. We advocate, me in particular, advocate employment law. I have done that for over a decade now. We also advocate ACC issues, and in some cases, residential tenancy issues. Predominantly, lawyers and advocates aren't really supposed to attend residential tenancy matters, but when there's problems with language barriers and sometimes the applicants have mental health issues, then sometimes we are allowed to go in and bat for them. So more and more in terms of the Employment Relations Authority, mediation services, we're finding that people, when 10 years ago it was heaps and heaps of lawyers and not so many advocates, now it's a lot more advocates and not so many lawyers because people just can't afford to pay for them. Even the employers themselves are using advocates rather than using lawyers, because at the end of the day, someone has to pay the fees, and lawyers' fees are just out the gate. I also, in terms of going to court for civil matters, act as a certified Mackenzie friend. There's probably some of you online tonight who has no idea what a Mackenzie friend is. The idea of a Mackenzie friend come from a 1970 case, Mackenzie versus Mackenzie, where Mr. Mackenzie decided he was going to self-litigate, and he asked the judge if he could have a support person with him who was a lawyer, and the judge said no. So they appealed that, and the appellate court came back and said, actually, Mr. Mackenzie can have a support person in the form of a Mackenzie friend, and that is clearly why we are called Mackenzie friends. We don't get to have an audience with the judge. We are simply there to support the self-litigant, organise their papers. We're allowed to talk in their ear and remind them, we are now going to talk about this case here, this principle of this case, etc., etc. So we're there beside them all the way through their case to help them. It's not a foregone conclusion that you can be a Mackenzie friend for somebody. You actually have to seek leave from the court, which is permission to be their Mackenzie friend. The court needs to know that the Mackenzie friend has a little bit of legal knowledge. Like Helen, I have been to law school myself, and they need to know that it's just not going to you're not going to get into court and it's going to be just a whole lot of somebody that doesn't know what they're talking about. It gets out of hand. So that's the type of stuff that we do, and I also work alongside with Families for Justice, which is helping people navigate the family court, family group conferences, oranga tamariki, all that type of thing. Families for Justice has been around for about 10 years, and it was founded by a gentleman called Steve Evans, who funded it himself, the organisation, for 10 years, and he was seeking justice when he was trying to protect his children from Operation Phantom, which was a huge family case at the time. His children were involved with people who from the triad, and there was guns and all sorts of things in the house, and he was trying to protect the children, his own children, and nobody would listen to him. So he's done an awful lot of work in that field over the years, and I'm really privileged to be part of that as well. So I do quite a bit. So that's me.
Thank you, Jen, and thank you to the team here. We've got a great team, as you can see, the audience watching the Conservative Party. If you are concerned about access to justice, if you want access to justice, please vote for Conservative Party to bring us in, and we can advocate a little bit more as well on other areas. Now, we've got a comment here from Carl. what can be done to address sentencing that does not meet the community's expectations? There has been a few recent examples, and he's also said awesome. Does anyone want to take that one?
I'll just make a comment on the sentencing in terms of what seems to be what I call the default discount. There seems to be a number of reasons as to why the court will allow discounts for sentencing. My argument against that is that the person who's been hurt doesn't get a discount for harm. It's not like we can retrospectively go back and go, well, we'll just discount the impact upon you, shall we, at the same time. There's a gross injustice just in that very process. So I'm not a fan of discount for sentencing, because we can't discount the harm upon the person who's the victim.
Good response. Thank you. And thanks for your question, Carl. Right, so we only came on for about 30 to 40 minutes tonight, just a quick live catch up. If you do have other comments or questions, you can put them in and we will endeavour to get back to them later on. We will be having weekly catch-ups with different members of our team in the Conservative Party. We have great expertise across many other areas, and you'll get to meet many of our other candidates and spokespeople over the next few weeks. Thank you for tuning in tonight. Thank you, Jan, Ross and Stephen. Great to have you beside me. It's actually really good to have a wee team here instead of it just being my face. So yeah, a great interview. Thanks, team. Good night, everyone, and thank you for joining us tonight, those who are watching.
Thank you, Helen.